In this lecture, we would be discussing law of social security, employment injury, compensation, and insurance. So, welcome to this comprehensive overview of social security law in India. This presentation is designed for law students and legal professionals, offering an in-depth look at key legislative frameworks, essential provisions, and landmark judgments shaping social security law in this country. We would try to explore the critical areas of employment injury compensation, retirement security, maternity benefits, the liability of principal employers, all within the context of evolving code on social security 2020. Our aim is to provide clarity and practical insights into this vital area of Indian labor law. Employment injury compensation, it safeguards workers. Employment injury compensation is a cornerstone of Social Security, ensures financial protection for employees and their dependents against accidents and occupational diseases arising or during course of employment. This vital provision, initially governed by Employees Compensation Act 1923, is now integrated into Comprehensive Code on Social Security 2020. Types of disablement: temporary, total, complete inability for a temporary period, permanent, total, complete and permanent loss of earning capacity, temporary, partial reduction in earning capacity for temporary period, permanent, partial, and permanent reduction in earning capacity. These are kinds of disablements. Compensation calculations are precise. For death, it's 50% of monthly wages multiplied by relevant factors based on age. The permanent total disablement, that is 60% of the wages times same factor. A landmark case, Pratap Narayan Singh Dev versus Srinivas Sabata, affirmed the employer's immediate liability independent of judicial determination. Employment injury insurance, which is one of the most significant legislation that is popularly known as ESI, and even labor class is known ESI, hua ke nahi, a collective shield. Applicability applies to factories establishment with 10 or more employees, where the monthly salary of an employee is below 21,000. This broad coverage ensures a safety net for a significant portion of organized workforce. A contribution model, the scheme operates on shared contribution model. Employer's contribution is 3.25% of the wages, while employees' contribution is 0.75%. This collaborative approach funds the comprehensive benefits provided under this act. Benefit structure: key benefits include injury benefit 90% of which during medical leave, disablement benefit for partial or total disablement or depends upon dependence benefit in case of employee's death. This, these benefits aim to provide financial relief and support during periods of vulnerability. The Employees State Insurance Act 1948 is a critical pillar of Social Security, providing comprehensive health and financial coverage for workers and their families. It represents a progressive step towards ensuring the well-being of industrial workforce, offering protection against health-related contingencies and loss of wages due to sickness, maternity, employment, injury. Retirement security, provident fund, and gratuity. Provident fund, that is popularly known as PF, mandated by Employees Provident Fund and Miscellaneous Provision Act 1952. PF ensures long-term savings for retirement. Both employees and employer contribute 12% of wages. Applicability, it applies to establishment with 20 or more employees, ensuring a wide reach for retirement benefits. Formula, calculated as 15 days wages for each completed year of service based on the last dawn salary. Gratuity, payment of Gratuity Act 1972. Gratuity is a statutory payment to employees with 5 years plus years of continuous service. Most of the working professional must be knowing about gratuity concept. Retirement security in India is primarily bolstered by two key provisions, Provident Fund and gratuity. These mechanisms are designed to provide financial stability and dignity to employees post retirement, acknowledging their dedicated service over years. The legal frameworks for both, now largely consolidated under the Code on Social Security 2020, underscores India's commitment to worker welfare. Maternity benefit laws supporting motherhood. Nowadays, the people are advocating being in nuclear family setup, advocating for paternity leave also, and in some corporations, it is being started giving by HR policies. Extended leave. Uh, 2017 amendment significantly extended paid maternity leave to 26 weeks for first two children from previous 12 weeks, demonstrating a progressive approach to maternal welfare. Work from home and crèche. The act introduced provisions for work from home options and mandated crèche facility in establishment with 50 or more employees, fostering a supportive work environment. Though enforcement is again a problem, we see crèches are usually not there in every establishment. Adoption and surrogacy. It also includes 12 weeks of leave for adoptive mothers for a child under 3 months and commissioning mothers, ensuring comprehensive coverage for various forms of motherhood. Maternity Benefit Act 1961, significantly amended in 2017, stands as crucial legislative instrument for protecting employment of women. During the period of maternity, this act applies to all establishment employing 10 or more people, encompassing both organized and unorganized sectors, and aims to ensure that women are not deprived of their livelihood or subjected to unfair treatment during crucial phase of their lives. The landmark case is Shah versus Presiding Officer, which comes from 2001, reiterated that denying maternity benefit infringes upon fundamental rights, especially under Article 21, right to life and personal liberty, and 42, provision for just and human conditions of work and maternity relief. Liability of principal employer, extending accountability. Government departments. For government departments, the head of department is designated as principal employer, responsible for compliance and liabilities. Factories and establishment. In factories, other establishment, the owner or occupier is deemed to be the principal employer holding direct responsibility for workers' welfare. Contracted work, even for outsourced work through a contractor, principal employer remains liable, ensuring that workers are protected regardless of their direct employer. Concept of principal employer is crucial under India's social security laws, particularly in ensuring that workers, especially those employed through contractors, receive rightful benefits. The Code on Social Security provides a comprehensive definition, extended accountability beyond immediate employers to entitles ultimately benefiting from work. This broad interpretation ensures a robust safety net for uh, contract labor, a significant segment of India's workforce. The principle was reinforced with ES IC versus Harrison Malayalam Limited, affirming principal employer liability even for workers not on direct payrolls if their work relate to principal employer's business. The Code on Social Security 2020, a new era, consolidates 9 central labor laws into single code, simplifying compliance administration. This streamlines the fragmented legal landscape of Social Security. Future Ready addresses the evolving nature of work while including provisions for new forms of employment like gig and platform work, ensuring their inclusion in Social Security. Universalization aims to extend Social Security benefits to unorganized sectors, gig workers, and platform workers, significantly broadening the scope of coverage. The Code on Social Security represents a monumental shift in India's social security laws. It aims to universalize social security coverage and simplify the existing uh, landscape of labor laws by subsumming acts like Employees Compensation Act, Employees State Insurance Act, Employees Provident Fund, and Miscellaneous Provision Act. The code seeks to provide a unified and comprehensive framework. This new code is particularly significant for its efforts to extend protections to previously uncovered segments such as gig and platform workers, ensuring that no workers is left behind in the pursuit of social justice and welfare. Now, I would be concluding this lecture on social security laws. Uh, Social security law in India is fundamentally about ensuring income protection, dignity for workers across various life contingencies, be injury, illness, maternity, old age, death. The journey from fragmented legislations to comprehensive code on social security 2020 reflects India's evolving commitment to worker welfare. This code aims not only to streamline existing provisions but more importantly to universalize and simplify coverage, particularly extending crucial protections to emerging classes of workers such as gig and platform workers. As India progresses, implementation and continuous refinement of this code will be vital and significant in fostering a truly inclusive and equitable working environment, ensuring that dignity of labor is upheld through robust social security mechanisms. This emphasis on adaptability to new forms of employment signify forward-looking approach critical for India's dynamic economy. With this, I would end here. Happy learning.